Guyana passed its Juvenile Justice Act in April. It is currently before the Attorney General's chambers for the issuance of the commencement order. When this act comes into effect, it will bring with it sweeping changes regarding the treatment of juveniles who commit acts otherwise considered criminal in the eyes of the law.
The inaugural Green Guyana Expo is almost here at the National Stadium Tarmac, October 18 to 20. Come and experience green living, green technologies, green agriculture, and so much more. Gates will be open 2 p.m. daily, and admission and secured parking is absolutely free. Enjoy live entertainment throughout the event with food and drinks and exciting games for the kids. Come out, learn green, go green. Let's experience our future together.
The Guyana Press Association collaborated with the United Nations International Children's Emergency Fund, UNICEF, to sensitize media practitioners about the Juvenile Justice Act 2018 and the need for responsible reportage on juvenile matters. Minister of Public Security Kemraj Ramjatan highlighted preparations deemed necessary for the effective implementation of the Act.
We have to have what is called a number of things in place before we can have what is called the completion of the works to ensure the effective and the effectual implementation of the Act. We still have not appointed a director of juvenile justice. We have not appointed the members of the board of the Juvenile Justice Committee. We haven't as yet gotten the temporary facilities which we want so that the children who have been, to use the old word, remanded, where they will go, rather than the state of things now. We would prefer them in better facilities, far more accommodating, and so on. And a whole set of other paraphernalia that goes along with the extremely revolutionary regime that we have in this Juvenile Justice Act.
The minister added that a Juvenile Justice Committee will be established and appropriate staff identified and trained.
One of the things that makes ACT work are the resources to see through the implementation of all those. The Juvenile Justice Committee, the director, you have to look after his salaries, you have to give him a staff, you have to give him a building, you got to light up the building, you got to put computers in it. All of that costs money. You have to also reorganize the social workers and the psychologists and the psychiatrists that might have now to be trained for purposes of working with the director of juvenile.
Chief Magistrate Anne McLennan explained some aspect of the Juvenile Justice Act. She first explained what is meant by the term juvenile in the eyes of the courts.
The Act has increased the age of culpability from 10 years to 14 years. And it defines a juvenile as a person who is, or in the absence of evidence to the contrary, 14 years old, but less than 18 years. So no one who is 13 years and who has not yet been 14 years or who's 14 years cannot commit an offense. So you can't charge that person and bring them before the court. And then if you're 14 to 18, then you become a juvenile and then you can be brought before the court. So they have no capacity. You can't, in law, you're not capable of committing an offense if you're 14.
The Act has repealed a number of provisions which previously governed juvenile justice. It incorporates international juvenile justice standards and is in keeping with Guyana's international commitments.
The Act, when it comes into force, will repeal the Juvenile Offenders Act. It means that the Juvenile Offenders Act will nothing in there will be of any law. So once that Act comes into place, there will be no the Juvenile Offenders Act will be repealed, and the Training School Act, Sections 15, 16, and 26 will be repealed, and also provisions in the Education Act will be repealed, and the Parole Act also has some sections which will repeal. I'll deal with these later on. It has also amended Section 2, 7, 9, and 11 of the Probation of Offenders Act and the schedule to the Rehabilitation of Offenders Act. Part 7 of the Act deals specifically with the section of the Act referred to above, which are amended and repealed. The Act in its present state now reflects international juvenile justice standards in keeping with the Beijing rules, the Riyadh guidelines, and the United Nations Convention on the Right of the Child. So we're coming more and more in compliance with these conventions that we, Guyana, have signed on to. So we ought to be on board with our legislation.
Facilitator Professor Paloma Mohammed said the Act's provisions are good for the country given that the majority of its citizens are youth.
When I learned about this Juvenile Justice Act and what it could mean for Guyana, I was deeply moved by it because, as we know, over 60% of our population are deemed as young people. And if they're in trouble, it means the country is in deep trouble.
Juvenile justice is now tempered with considerations such as the age of the deviant child, reformation rather than punishment, and rehabilitation rather than criminalization.
The Act also provides for several alternative and diversional measures and emphasizes restorative, rehabilitation, and reintegration measures. Provide for alternate sanctions which may be imposed on culpable youth in conflict with the law. With the implementation of this Act, all statute offenses were repealed, for example, wandering and truancy. So those will not be offenses anymore. It is important to note that with the implementation of the Act, when a juvenile is in conflict with the law, there will be, in most instances, much interaction before they even come to the court with the police, probationers, attorneys, and the DPP chambers to determine whether the matter can be conducted by way of diversion or warnings, etc. So when a juvenile is arrested, they will be taken to the DPP and they will discuss whether or not the child should come to the court. So those are diversionary measures. So if they can find diversionary measures, then the child never comes into the court system. However, whatever transpires at that stage of the process cannot be admissible in the court to prove prior offensive behavior of a juvenile. So if that is dealt with, then if there is a subsequent court matter, the police, the prosecutor cannot use that instance to say, well, the child it's a repeat behavior. That is not admissible. The court is not allowed to accept that or to consider that evidence in any other matter that appears or comes to the court.
Minister Ramjitan thinks youths should be reformed at an early stage since it costs the state too much to deal with them as criminally involved adults. The Chief Magistrate Anne McLennan explained the roles of the Juvenile Justice Committee and the Director of Juvenile Justice previously alluded to by the Minister.
It provides for the appointment of the Director of Juvenile Justice. And this person, who will be appointed by the Minister, has the responsibility for development and maintenance of the diversion programs. There is also provision for a Juvenile Justice Committee to be appointed, which has specific duties assigned under the Act. And some of their duties include visiting and supervising the facilities, taking complaints and reporting to the Minister. And this committee also has to be appointed by the Minister.
A request for evaluating a juvenile who appears before the courts can be made by an attorney, Director of Public Prosecutions, or the prosecutor. The court is responsible for ordering that evaluation by a suitably qualified person at the state's expense. Chief Magistrate McLennan explained the importance of this provision.
This means that, for example, if a child comes before you and you're not sure if the child is, from looking at the child, you may not have a birth extract, or you may have no information as to the age of the child. So, to determine the age of the child, either of these parties can make an application to the court, an evaluation could be done of the child, and the person who does the evaluation can say, well, the child might be 17, but the capacity is 10. And therefore, in those circumstances, the cases will be referred to the Director of Child Care and Protection Agency, and the Director of Public Prosecution will withdraw the charge, because if they're below, then they will have no capacity, and therefore you cannot bring them before the court.
The court is also given exclusive jurisdiction to deal with any person who may have allegedly committed an offense while that person is a juvenile.
Either if the offense was proved that the person committed the offense before they attain the age of 18, then the sentence will be in accordance with the act. And if not, then they will be sentenced as an adult. So they may have committed the offense when they were 16, but by the time the matter comes to the court or 17, they're 18. The court can still deal with the matter. But before sentencing, we'll have to determine whether they committed the offense before or after 18, and that will determine the nature of the sentence. And the act also says if you were given diversion measures at 17, and they, for example, for 2 years, then they will continue even after you'll have attained the age of 18. A point to note also is that no private prosecution can be brought without the written consent of the Director of Public Prosecutions. So as the law is right now, persons can bring private actions against other persons. But this act says that if you're going to bring a private action against a juvenile, then you must have the consent of the Director of Public Prosecutions before even filing that matter. The act puts an obligation on the court also to ensure when it reads the charge to the juvenile that the child understands it, and the court also has the obligation to direct that the child be represented by counsel. The court also has the obligation to ensure that the juvenile has sufficient time to retain counsel. And the court is also obligated to refer to legal aid if it is the juvenile wants counsel and cannot afford counsel. Then the court has the obligation to refer the juvenile to legal aid for aid and/or appoint an attorney to act on behalf of the juvenile.
UNICEF resident Representative Sylvie Foyer hailed the Juvenile Justice Act as forward-looking, offering the opportunity for a new beginning for juveniles.
We cannot get this bill alone, so education and information are a very important part of it. As you mentioned, the main interest is really to get a young-friendly environment in Guyana, but also, I will use a word, I saw the questionnaire you have as diversion, but also if you may use the word of second chance. So if you had, some time, off track, lost track, it's how you bring back that second chance to the juvenile, especially the youngest, then to become, productive and thriving adults. As we say earlier, is really how we bring justice for children, but in a different way, or in a way that has ensuring things are changing regarding perception of children in contact with the law, but also finding solutions for them. And that's why a lot of other pieces will be needed, and what could be an alternative way of, like I say, bringing them back a second chance and back on track.
Deputy Chairperson of the Rights of the Child Commission, Rosemary Benjamin Noble, encouraged media operatives to pay keen attention to the Juvenile Justice Act and its provisions for the protection of the rights of the child.
In this context, especially, responsible reporting is important to be practiced at all times. Now, there is no place here for sensationalism. It is expected that all reporting would be faithful in observing these rights. Therefore, I exhort you to always remember that children's rights are human rights. We are also dealing with the definition of diversion, which means the redirection of a juvenile from the formal court procedures to informal procedures. And terminology is very important. So using terms such as inmate and convict and so on, we urge you to strongly move away from using those terms. Because in using those terms, you are practicing stigmatization. And so you're not really helping the child or the juvenile to move forward. The best interest of the child is of paramount importance. The well-being of the juvenile must be promoted. The detention is to be a last resort or option. And encouraging the family of the child or juvenile to act and take responsibility for the child or juvenile. Rehabilitation, education, reintegration. That basically is the foundation of this piece of legislation. And they're all in the best interests of the child.
This has been InfoHub Extended. Thank you for joining us. Goodbye.